Imagine you're in your home having a private conversation with your friend. You're sharing detailed information about your personal life, including the new relationship you've just started after breaking up with your ex. What you are unaware of is that your ex, who never lived in the home and nor had a key, broke into your home and bugged your home while you were away. They're now listening in to find out who the new person you're dating is. A few days later, the person you're currently dating tells you that someone described as looking like your ex has started following them around and has been bothering them, and you soon piece together the puzzle. Your ex has invaded your privacy by intrusion. My name is Jade, and also in the group are Grace and McKenzie, and our topic is the tort of intrusion. So, as illustrated in the previous example, intrusion is when one intentionally, either physically or technologically, disturbs or interferes with someone else's private affairs when that person had a reasonable expectation of privacy. Examples of intentionally interfering include bugging rooms to get audio or video of a person, using drones to watch what people are doing, and even having paparazzi follow around celebrities and taking photos of them. According to our textbook, The Law of Journalism and Mass Communication, the tort is intended to ensure that people can protect their dignity by preventing unwanted encroachment on their private affairs. However, celebrities' private affairs are often viewed as interesting and sometimes even newsworthy for the public. After Princess Diana's death, which was caused when she was trying to escape the following of paparazzi, California passed an anti-paparazzi law. It stated that offensively trespassing to photograph a person was an invasion of privacy. Also in 2013, California passed another anti-paparazzi law, and this time the focus was on protecting the children of celebrities. So Jennifer Garner and Halle Berry testified in favor of the law that increased penalties for harassing children because of their parents' jobs or status. So we actually have a video on that here.
An emotional fight between the public and the paparazzi. Actress Jennifer Garner broke down in tears today, describing a daily assault by aggressive photographers determined to get photos of her and her children. ABC's Nick Watt has that.
Today, Jennifer Garner took her family's fight against the paparazzi to California's State Assembly.
I don't want a gang of shouting, arguing, law-breaking photographers who camp out everywhere we are, all day, every day, to continue traumatizing my kids. Thank you for the opportunity to testify today. Sorry.
It is completely legal to photograph celebrities' children, but Garner and fellow actress Halle Berry are championing a bill that would make a snapper who, quote, seriously alarms, annoys, torments, or terrorizes a child in the process liable to fines and jail time.
We aren't just whiny celebrities that many times people think we are. We're moms here who are just trying to protect our children.
Recently, I rode along with an unrepentant LA paparazzo.
Personally, I feel like I'm still showing the mass market what they might want.
Celebrity magazines publish the photos. An unfair price, says Garner, simply for having famous parents.
The price paid for pictures of celebrity children is now absurdly high. They have a bounty on their heads every day. Being stalked has been hard for me, but it's beyond what a child should have to endure.
Nick Watt, ABC News, Los Angeles.
So that takes us to intrusion by trespass, which has three parts. The plaintiff had a reasonable expectation of privacy. The defendant intentionally intruded on that plaintiff's privacy, and the intrusion would highly offend a reasonable person. In the example I used in the introduction, you being in your home talking with your friend, you had a reasonable expectation of privacy. You, as well as any other reasonable person, would have an expectation that no one would break into your home and bug your home while you weren't there in order to capture video of you talking with your friend. Your ex purposely entering the house to hide that device to record was an intrusion of your privacy, as they did not have permission to be there, and a reasonable person would be offended that your ex broke into your home and hid the device to begin with. So entering a person's land or property without their permission is intrusion, which is very similar to a trespassing. Trespassing is both an intentional tort and can be punished as a crime under certain instances. Trespass is held in tort law as the owner's legal right to enjoy the benefits of ownership of the property. So one who trespasses is a trespasser, and they could be sued for intrusion. As you can see, the two are very similar in their descriptions. As with many instances in law, the key of intrusion is, would the intrusion offend a reasonable person? So again, the reasonable person standard does come into play with intrusion.
All right, so we're going to go into some defenses to intrusion. There are three big ones. The first one is consent. The key is that it must be informed consent from somebody who is legally able to give it. And the best way to get it is in writing. So basically, if somebody gives you consent to record them or film them, then that is a defense that you can use. The second one is false pretenses. It is often used by reporters when they use deception to gain access to places that have newsworthy things going on. The important part is that the defendant must have a valid reason to be on the grounds that they are on. For example, an anonymous food critic who is going to write a bad review of a restaurant is allowed to do that because a regular person has every right to be in a restaurant. An example where that wouldn't work is if somebody pretended to be a handyman to gain access to somebody's private home. They have no reason to be there, so that would not be an effective defense. And then tying kind of into false pretenses is newsworthiness. This is a rare defense because, according to our textbook, publication is not part of the plaintiff's burden of proof. In other words, just because something isn't published doesn't mean it can't be intrusion. However, the defense can be used if what is being reported on is important for the public to know and is more important than somebody's privacy concern. For example, a reporter using false pretenses to secretly record a medical lab's testing errors. The public's right to know about those errors is more important than the lab's right to privacy.
All right, so the first Supreme Court case that we will be looking at is Katz versus United States, which took place in 1967. So this was a landmark decision of the U.S. Supreme Court, which redefined what constitutes searches and seizures in regard to the Fourth Amendment protections. So to begin with the facts, the case involved Charles Katz, a man from Los Angeles who specialized in wagering on college basketball. The FBI began investigating his suspicious gambling activities, and in 1965, they acted on a suspicion that he was transmitting gambling information over the phone to clients in other states by secretly recording him. The FBI attached a covert listening device to a public telephone booth near his apartment that he used to make these calls. And then based on the recordings, Katz was then convicted under an 8-count indictment for the illegal transmission of wagering information across U.S. state borders, as he had clients in both Boston and Miami. On appeal, Katz argued that the recordings could not be used as evidence because the telephone booth he used should be considered a constitutionally protected area under the Fourth Amendment, and therefore the recordings should be excluded as evidence since the FBI had not obtained a search warrant in order to tap the telephone booth. However, the Court of Appeals rejected this point, noting that there was an absence of a physical intrusion into the phone booth itself and affirmed the lower court's decision. So this brings about the question, did the government's eavesdropping violate Katz's Fourth Amendment protection against unreasonable searches and seizures? And the answer to that question is yes. The court ruled that Katz was entitled to Fourth Amendment protection and that police are required to obtain a search warrant in order to wiretap a public payphone, or any phone for that matter. The court argued that a physical intrusion was not necessary to bring the Fourth Amendment into play. As Justice Potter wrote, the Fourth Amendment protects people, not places. This decision significantly redefined the law governing the Fourth Amendment's protections, which previously limited to just tangible items. Spoken of in the Fourth Amendment, the protections were limited to searches and seizures of individuals' persons, houses, papers, and effect. So again, just those tangible items. However, after this ruling, the court expanded the amendment's protections beyond the traditional areas of physical intrusion or trespass, stating that what a person seeks to preserve as private, even in an area accessible to the public, may be constitutionally protected. This meant that those recordings and other private digital content would be protected under the Fourth Amendment, which of course is especially important in this day and age and is becoming ever more important as everything moves online and we have all of this digital content now. The dissent, which consisted of only Justice Hugo Black, argued that the Fourth Amendment was only meant to protect physical things from search and seizure, and that it was not meant to protect personal privacy. He also argued that if the drafters of the Fourth Amendment had meant for it to protect against eavesdropping, since this was a common thing back when the Bill of Rights was drafted as well, that they would have included the proper language to do so. So in conclusion, the court ruled in favor of Katz with a 7-1 decision. A test was also created as the result of this case. So Justice John Marshall Harlan II interpreted this opinion of the court to require claims of Fourth Amendment protection to pass a 2-part test, which has come to be known as the Katz test. So the first part of this test is that the person have exhibited an actual expectation of privacy, and the second being that the expectation be one that society is so prepared to recognize as reasonable. So overall, this case greatly expanded the scope of the Fourth Amendment's protections, and the Katz test will also be referenced in the following case that Jade will discuss next.
So our second Supreme Court case that we looked at was Kylo versus the United States. This happened in 2001. So for the facts, police had used a thermal imaging device at Danny Kylo's house after a detective had suspected that he was growing marijuana in his home. The thermal imaging device indicated that there was a certain amount of heat that was presumably coming from grow lights within his home, and based on information that was provided from the imager, police were then able to obtain a search warrant to actually go into his home, where they did find him to be growing marijuana. So Kylo was indicted on a drug charge. The trial and a court of appeals held that since Kylo made no effort to hide that he was escaping from his home, that there was no expectation of privacy there. Furthermore, the imager did not expose any intimate details of his life, so that all means that the police did not technically invade his privacy. Since the thermal imager was not in public use, it was not seen as a violation of the Fourth Amendment either. So then a writ of certiorari was granted to determine if the thermal imager was considered a search under the Fourth Amendment. That brings us to the issue: is the use of a thermal imaging device an intrusion of or invasion of privacy? So again, the big factor here of the issue was determining if there was a search or not with this whole thermal imaging process. So to determine whether or not it was a search, as they did not actually go into the home, the courts used a principle from the Katz versus United States test that we just talked about. So it's the Katz test, again, which is whether an individual has an expectation of privacy that society also views as reasonable. For the search of the interior of homes, the courts found that there was at least a minimal expectation of privacy that does indeed exist. So to remove that expectation of privacy would violate the privacies guaranteed by the Fourth Amendment, those being persons, houses, papers, and effects. Justice Scalia, delivering the opinion of the court, said that reversing the Katz test in this instance would place homeowners at the mercy of advancing technology. As we as a society and even as a world advance, there are continuous technological advances that put us at risk for our information and privacy to be intruded upon and violated. When the U.S. Constitution was written, there were no thermal imaging devices. So that being said, the courts must continuously adjust and evaluate these things as potentially violating the U.S. Constitution. In the case of Kylo versus the United States, they did just that by protecting people from the interiors of their homes from being searched, keeping the Fourth Amendment intact here. So again, the rule of law here was, yes, the use of a thermal imaging device is an intrusion of privacy. So in a 5-4 decision, the Kylo won the case, as the use of an imager was not seen as a search, and it was done so then without a warrant, which is unlawful under the Fourth Amendment. The dissent was that the observances were more so off the wall rather than through the wall and into his home, meaning the police's conduct was not grounds to truly be called a search. So having an expectation of privacy in one's home is a cornerstone of living. What things would you or would you not do if you knew that someone could legally look inside your home with a thermal imaging device? What things would you or wouldn't you say if you knew that you could be wiretapped or bugged by an enemy legally? Communication and the ways we communicate as we know it would be drastically different.
So we're going to wrap up with the overall significance of the intrusion tort, the so what. And like Jade was just saying, without the intrusion tort being available to us, there would be a big impact on our communication, somewhat of a chilling effect. We would be afraid of how we conduct ourselves in private in our homes, how we talk to others, how we express ourselves, if we knew that people could legally just record us or wiretap our phones. And then as we've been saying through all of these cases, there is a reasonable expectation of privacy under the Fourth Amendment. The intrusion tort helps us preserve this expectation and protects our right to liberty that is guaranteed in the Constitution. It also gives us a tool to fight back with if these rights are violated.
And then our references. So thank you guys.
Thanks.